Good afternoon, Your Honors. May it please the Court, Ben Ball on behalf of the state.
Mr. Ball, I know you're not used to this side, but would you like to reserve any time?
I would, Your Honor. You're correct. I'm not used to it. I'm used to that, and I appreciate the reminder. I don't know that I'll need them, but I would like to reserve 2 minutes of time. One of the fundamental characteristics of our justice system is that it relies upon the crucible of adversarial party presentation. This case illustrates the importance of that system. Here, the defendant appealed his convictions for aggravated sexual battery, raising several issues. In addition to the issues raised by the defendant, the Court of Criminal Appeals considered an issue not raised by either party: whether the written instructions submitted to the jury were consistent with the oral instructions given to the jury. After supplementing the record with the transcript of the oral jury charge, the Court of Criminal Appeals compared the written instructions that were included in the technical record with the transcript, and concluded that numerous instructions had been omitted from those written instructions. Without notice to the parties or request for additional briefing, the Court of Criminal Appeals found plain error and reversed. Upon receiving this opinion, our office got a call from the district attorney, who had compared the instructions and determined that the technical record had been mistransmitted to the Court of Criminal Appeals. It was missing approximately 16 pages. Based upon this, our office filed a petition to rehear, which the Court of Criminal Appeals denied despite the trial court supplementing the record with the complete instructions. During the pendency of this appeal, this court asked the trial court for clarification as to which set of written instructions were actually submitted to the jury, and the trial court found affirmatively that the instructions in the technical record were incomplete and that the supplemental instructions from the petition to rehear were accurate. Thus, the Court of Criminal Appeals' finding of plain error was premised upon a mistake, and we asked this course to reverse for two primary reasons. One, the Court of Criminal Appeals erred by deciding an unraised, dispositive issue without notice to the parties or an opportunity for the parties to be heard. Appellate review is typically limited to the issues presented. Appellate courts do have the discretion to consider other issues, but they should not do so without notice to the parties or without giving the parties an opportunity to be heard.
Is your problem in this case the notice? I mean, I guess, is it your position that had the court at least provided the parties with notice that it was going to consider this issue and an opportunity to be heard, that it would have been proper for the court to consider this issue? I mean, are there factors that must be met for a court to even consider an issue in the first instance that has never been raised by the parties?
Well, certainly the Court of Criminal Appeals considers issues not raised by the parties all the time, and we're not contending that that is inappropriate per se. It's inappropriate when the parties aren't given notice and the opportunity to be heard. The fact that it has not been raised, of course, is impacted by the level of review that's available. The court's going to be obviously limited to plain error review, but that the parties should still be given notice and the opportunity to be heard. And we can see this in the language of plain error review. It talks about the party who, the appellant, having the burden of establishing plain error. But in a case where neither party has been given notice that the court is considering that issue or the opportunity to be heard, it's impossible for either party to meet that burden.
Is it even necessary for us to make that finding and decision? Isn't it enough that there was a mistake here in the fact that the oral instructions were consistent with the written instructions, therefore there was no plain error?
And that is my second point here, okay. that absolutely, that there simply was not plain error here, and which the record reveals. And that is, frankly, a fairly simple issue.
What about the petition to rehear? I mean, I think you can maybe justify everything that happened with the CCA until they got to the petition to rehear. Where did they go wrong there?
That's a good question, Your Honor. And I'm still a little baffled as to how it reached this point. And I think that the best that I can take away from this, the petition to rehear is not an adequate remedy for a failure to be heard below. I don't know where this went wrong. asked the court initially in the petition to have the trial court put down an order explaining these differences. Instead, the Court of Criminal Appeals ordered that the record be supplemented with the instructions that were actually given to the jury. That's what happened, but the court chose not to rely on that supplementation.
If we were going to outline the parameters under which an appellate court should address an issue that's not been raised by the parties, and I've certainly been on the appellate court since 1995, and early on embarrassed myself in an opinion addressing an issue that the parties hadn't raised, and quickly got a petition to rehear, making it clear that I didn't know what I was doing. They didn't say it that way, but that's how I took it and learned the lesson from it. But if we were going to outline parameters, but having said that, appellate courts sometimes do see issues that really do need to be addressed, issues that the parties haven't raised. If we were going to outline parameters for that, what would those be?
Your Honor, I think the parameters are already in place. I think they've just largely been ignored by the Court of Criminal Appeals for quite some time.
Well, let me ask you this. I mean, I was on that court for about 4.5 years, and there were times where it was clear that something might have been a D felony, and the judgment form had C felony on there. No question about it. Should the CCA have to send that back, or can we just correct it ourselves because it's so obvious?
Well, Your Honor, I think what you're talking about there is a clerical error. And the rules say a clerical error can be corrected at any time. When we have a sentencing transcript where it's obvious, where the trial court says, this is the sentence that I'm giving you, and it's going to be 12 years. And the judgment form says 13.
Let me give you a little harder one. How about merger? You know, everybody said that two offenses should have been merged, but you got separate judgments. Where do you draw the line?
Merger is probably one of the most common plain error issues that we see. And it's certainly something that the court can consider. We just ask that the state and the defendant be given the opportunity to be heard on that issue.
What does the opportunity to be heard entail? I mean, does it depend on the case? Does it always involve an opportunity to brief the issue? Is it sufficient for it to be raised at oral argument and to have an opportunity to address it then?
I think typically it's going to be the opportunity to brief the issue, because that's normally how this plays out. We see the Court of Criminal Appeals is during that process. Now, I acknowledge that when we have a situation where we have oral argument, that could be a little different. If the court, for example, discovers the issue that they're interested in after oral argument. But at the very least...
but then parties can submit briefs after oral argument.
That is correct.
They are surprised by an issue raised by the court.
That is correct. And I think that would be more than sufficient, is to have the opportunity to brief the case, even if there's not the opportunity to be heard on oral argument. A wise judge once said to me in a CLE that it's unusual that a party will win a case at oral argument, but they sure can lose it. So I think that we're fine with just the briefing. But yes, the thing, if that would be crucial, that the state and the defendant have an opportunity to file a written response to the court's interest.
So if it's a merger issue, do you think the CCA should direct the parties to brief that issue on merger?
Yes, Your Honor.
Because that's more than a clerical error.
That absolutely is more than a clerical error. And there may be instances where, the state concedes that merger is appropriate, but there are certainly times where the state does not. And that's something that the parties need to be heard.
Don't we run the risk, if we set specific guidelines, of then having litigation within litigation over what is clerical and what's not, and some of those issues?
I'm certainly that there is some potential for that. Frankly, I don't think that's all that likely. That you see further complaints about the exact way this is, that notice and opportunity are provided.
For this case, the facts are so clear in terms of the relief that was granted was drastic.
Absolutely, Your
This
Honor.
is clearly not clerical or a close call. This was a big deal in terms of this ruling and the effect on these parties.
Yes, there were absolutely. I mean, this is the most drastic remedy that you could see as a result of just the mistransmission of the technical record.
If the appellant has the duty to provide an adequate record for review, and they fail to do so, how does this even get reviewed? I mean, typically, if you don't provide the record in the court, they cannot they didn't provide adequate jury instructions. How does that even happen?
That's absolutely correct. The appellant has the duty to prepare an adequate record for the issues they present. Of note here, the appellant, who was the defendant below, didn't present this issue. So it made absolute sense that would not have necessarily paid special attention to the portion of the technical record containing the jury instructions when the defendant's not challenging those jury instructions, and neither is the state. But had the defendant wanted to, that would have presented an impediment to it. Here, in a sort of unique situation, the Court of Criminal Appeals, they supplemented the record with the oral instructions to allow for that comparison. So the record was actually put together in part by the Court of Criminal Appeals here.
Is this defendant out on bail? I'm assuming not.
I would assume not. I do not know, but I would doubt it. And just very, very briefly to touch on the defendant's arguments on the supposed differences apparent in the jury instructions. To be clear here, what's at stake is that the Court of Criminal Appeals found that the jury instructions were missing many important instructions. They did not find that there were inconsequential minor discrepancies between the oral instructions and the written instructions. Found that there were instructions missing. That is not the case. And the discrepancies pointed out by the defendant, but not identified through citation, on the state's review of these, we're talking about omission of definite articles, and in some cases, slight alteration of the order instructions are given, but the instructions overall are verbatim. These are the same instructions. And when you see them, it makes it clear that the Court of Criminal Appeals erred by finding plain error here. If there are no further questions, I would ask that this court reverse the judgment of the Court of Criminal Appeals. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. I'm Thomas Parkerson, and I represent Mr. Bristol, and I would ask the court to reserve 5 minutes. I don't think we'll get to that. I think that I'll be done within my time.
You're on the other side too right now. You can get to reserve.
That's right. I've sat over there. Yes,
No,
sir.
I mean you're the appellee, not the appellant.
That's right, Your Honor.
So you don't get to reserve time.
Okay. All right.
All
Thank
right.
you. All right. So now, Your Honor, I think what the state has proposed in this situation is a question as to whether or not the Court of Criminal Appeals should provide notice to both sides as to whether or not there's going to be an issue if they find an unraised dispositive issue in the case. What I think is important to note, and I believe that this bench has asked this question just briefly, is when should they do that? What are the parameters in doing that? Is there already a way that we look at this issue?
Well, if we can, let's just jump to the
Sure.
other issue here, and that is whether, in fact, the oral instructions were consistent with the written instructions. And doesn't the record now indicate that, in fact, the CCA was wrong? That, in fact, the oral instructions and the written instructions were basically identical, and then there was no basis for the plain error finding?
Your Honor, I think that I would say that they don't. And here's why, Your Honor. When you look at the request from the Court of Criminal Appeals multiple times asking the trial court to certify the record, supplement the record, they initially asked for the transcript or the record which was submitted, and it did not have the found jury instructions. That was prior to the case being resolved at all through the opinion. Then subsequently, the Court of Criminal Appeals found that there was a problem. In the petition to rehear, they submitted the uncertified found jury instructions. The uncertified found jury instructions, then what the Court of Criminal Appeals did at that time was said, okay, all right, these are uncertified. I'm not going to decide your petition to rehear until a couple things happen. One, I want the defense to weigh in on this. And we were requested to file something with respect to that. Then they said, we're still not going to decide the petition to rehear. We want to see again, we would like the trial court to supplement the record with the actual certification. Please tell us, trial court, at this time that these are the actual jury instructions. It still was not certified by the trial court judge. The Court of Criminal Appeals had no option at that time to go ahead and find the way they did. It wasn't until this court received the case that this court ordered or requested the trial court judge to actually state, this is several years later, if this is the jury instructions that went back to the jury. So to answer your question, Your Honor, I think that the reason the Court of Criminal Appeals decided that these were not accurate was because it was never cleared up by the trial court as to whether or not these were the actual jury instructions.
But now that all that's been done, were they the same?
So, Your Honor, and this goes into a situation where you look back at the jury instructions, and again, this could be a court that wants to look at those instructions and see if they're the same or not and say this is a moot issue. But if we are going to do that, Your Honor, I think the problem with that is that if you look at the jury instructions that were originally submitted, there were 16 pages that were missing of jury instructions. Clearly many things that were missing. The later submitted jury instructions, the found jury instructions that were found after the opinion was filed and that were attached to the petition to rehear, they did match the oral instructions from the judge. However, when you look at the transcript from the proceedings and you look at the oral instructions from the judge, there were still inaccuracies on the order in which they were read.
Isn't that common in every trial? I mean, no trial is perfect. No court reporter is perfect.
That is correct, Your Honor. And I think in this particular situation, the order was so distinct, or not the order, but the discrepancy was so distinct that the Court of Criminal Appeals felt like that every time we keep getting supplemental transcripts, every time we are receiving new oral instructions, they still do not match. And I want to direct the court's opinion or attention to the Court of Criminal Appeals decision to deny the petition to rehear. If I may find that briefly, Your Honor.
Back to Justice Lee's question, though. Now that the record has been supplemented, other than the order in which the instructions appear, is there any other significant difference?
The significant difference, in my opinion, is that with the new found jury instructions, I still would state that when you match those found jury instructions to the instructions that were provided originally, they do not match. Now, I think the question you're asking, though, is do they match what the judge read? Okay? The judge has read oral jury instructions to the jury. They do match the oral jury instructions that were read to the jury. And
then what's the harm to your client?
well, the harm to my client, Your Honor, is that what was read to the jury, here's what the state poses in their argument, these are very likely missing jury instructions, that it was a possible issue that it wasn't submitted back to the jury. But here's my question, and I believe that it was brought to our attention earlier. These are the most serious cases. This client is still in jail. He was sentenced to 20 years. If the idea is it was likely that these were the instructions that were found, because here's what happens, and this honorable court understands this. In a jury trial, the judge reads the jury instructions. They have the oral instructions. They read those instructions. What is the method for the court to know that those jury instructions are the same ones that make it back to the jury? There's no doubt that this court read those jury instructions, but it would be my position that, and it would be the defense's position, that those jury instructions that were read were not the same jury instructions that went back. I do understand that the trial court judge has now, after being requested from the Supreme Court, asked to certify that those instructions went back. But the Court of Criminal Appeals asked them to do that too. And that was never done by the Court of...
So are you saying that it was an improper certification?
I am, Your Honor. I'm saying that, I'm not saying, what I am saying is that I don't believe, and this was the question that was asked, is do I think that the jury instructions that were sent to the jury were the same instructions that were read to the jury? I think the judge did read a set of instructions. I think those were the accurate instructions. I don't think those jury instructions went back to the jury.
How were they materially different? And if they were that materially different, why weren't they raised to the CCA as an original issue?
So they were materially different in the opinion of the CCA.
I'm not talking about the opinion of the CCA. I'm asking you to spell out for us today, with the certified record, how they were materially different to the effect that it unfairly prejudiced your client.
So they were materially different in that they did not list certain offenses. They did not list the definitions for certain charges.
Are you talking about lesser included offenses?
Lesser included offenses. It did not list the lesser included offenses, the elements of those offenses. I believe initially they left out the intentionally knowing.
Okay, I'm not talking about initially. I'm talking about what we have in the record today. Mm-hmm. So what's the difference today? Assuming that the trial court certified the record, and let's assume for a second that certification is appropriate, versus the oral instructions, as of today, what is the material difference?
There are no material differences
if
we take into account that the certification was correct. That's correct, Your Honor.
Was the Court of Criminal Appeals even reviewing that aspect of the jury instructions?
So during the course of our case and during the argument on the issues that were raised in this court, we did an oral argument. And in that oral argument, we brought up many issues, including some issues that came up at the closing argument. And the Court of Criminal Appeals, in reviewing those issues, recognized that we don't have a transcript regarding some of these issues that have been brought up. The Court of Criminal Appeals asked for the trial court to supplement the record with those issues. In reviewing that, the Court of Criminal Appeals realized that there was an issue with respect to the jury instructions, and I believe they
Doesn't this point to the whole problem in how this came up to start with? Because the burden, I mean, your client was the one who was looking for relief. It's your burden to have a record that supports what you assert. You didn't bring up this issue, so I'm not faulting you for not having the record in line on this, because you didn't raise this as an issue. But the fact that the Court of Criminal Appeals did not give the parties an opportunity to address it before it came out with the opinion turns it on its head. The burden should always remain on you to have to produce a record that supports an argument that would give your client relief. And here, it's just totally flipped and on its head.
That's correct, Your Honor. And if I may ask the question, I think you started it at the beginning of that statement. What was the question? Was it just a statement, Your Honor?
Nah, I'm just yammering.
That's okay.
You're just supposed to nod and say, that was brilliant, Your Honor, or something.
A position you're not normally in. I mean, you didn't invite this era. You didn't create it. The Court of Criminal Appeals handed you really a great win here.
Well,
What do you think, I guess, in what instances is it appropriate, in your view, for an appellate court to raise an issue that the parties have not presented?
I think that the court has looked at that issue, and on plain error issues that the court has decided, I think that they absolutely should raise those issues. And I think the jury instruction, hypothetically, if this really was, let's take away the for a moment, let's take away the certification, because it never was certified. The Court of Criminal Appeals never had that certification. So without that certification, and the Court of Criminal Appeals is looking at a massive issue, a substantial right to a defendant, then what they're looking at is if this defendant who is looking at an A felony and spending the rest of his life in jail did not have the proper jury instructions, whether it was brought up by the defense attorney or not, then we need to look at that issue. And then I think there are 5 factors the Court of Criminal Appeals looks at to decide if it is appropriate. The one thing that I think the general brings up, and it is a good point, is if there is an issue, and I think there's no discussion if we take the issue of the certification out, I think there's no contradiction or dispute that a lack of written jury instructions are a major substantial right to the defendant. If that's the case, then I think that the Court of Criminal Appeals has to look at those issues and use the 5 steps to determine whether or not it does fall under plain error review. Now, the problem is the fair notice.
Well, and I mean, what do you make of, because under plain error review, it really should be an error that is apparent, that is plain from the record. And so if the problem is that, well, we just don't know, we need more to even be able to determine whether there is an error, is that a proper time for the court to inject itself into?
You do bring up a very good point, and I think that in looking at the Court of Criminal Appeals, I think that's the first element, is does the record accurately reflect what happened in the trial court? And what the Court of Criminal Appeals had in the record was all that they could have had at that time, because they asked for supplements to the transcript. They asked for the transcript to be certified.
But even with plain error review, that's typically something where the defendant raises an issue, for example, to this court that was not raised below. So that still is, you know, most of the time, in fact, it should be a very large percentage of the time, where the defendant raises the issue. He says, I didn't raise it below, but we think we are entitled, appellate court, to plain error review, even though we did not raise it before now. Right? I mean, isn't that typically how that comes up?
I will nod and say yes.
Yeah, I added a question. I added a question on the end.
I have learned. I think that's exactly right, Your Honor, and I think that we're saying the same thing, because what happens with the Court of Criminal Appeals is, what if in a situation such as this case where it wasn't brought up, and what if it is a vital right? Should the Court of Criminal Appeals, and they see it, they don't go looking for it, but they come upon it, okay, in the course of their, let me see about this argument, let me see about this, and as the general says, they help to develop the record through the supplemental transcripts. But what if they see that issue and it wasn't brought up? Should a defendant be prejudiced because somebody didn't see a substantial right? And I think that the court has decided no. And the court has said, under plain error, that's when the Court of Criminal Appeals can address those issues. And I think they tried to do that in this particular case. And again, the issue is separate than if the certification is accurate. If the certification is accurate, there's not a distinction, a substantial material distinction between what was read to the jury and what the trial court judge says went back to the jury.
Do you in any way disagree with the state's view that if an issue is raised, then the parties should have notice and an opportunity to be heard on that? I
don't. And I'm kind of in a different spot, because typically, as a defense counsel, and I think it is part of the adversarial process, is that if there are issues that are brought up that neither party knew about, then I do think it's fair that both sides should be able to argue and talk about those issues. The question is, under what context? Do you do it through the petition to rehear? I think that the Court of Criminal Appeals tried to do as much as they could through the petition to rehear by asking, because I know that the state, the general submitted a very thorough petition to rehear and attached the certification of the, or not the certification, but the uncertified transcripts. Then the Court of Criminal Appeals didn't deny the petition to rehear. I think at that point they followed the next step and said, we want to hear from the defense counsel. So defense files their position. Then they decided they wanted to supplement the record. I think that was their purview or their idea let me hear from both sides before I make a decision. But if the court feels there's a different way that should be heard, I certainly agree that both sides should have a fair opportunity to be heard on something that nobody had anticipated. Without any further questions, I would respectfully ask this court to allow the Court of Criminal Appeals position to stand, and it was an honor to argue in front of the court. Thank you.
Thank you.
I know your honors have had a long 2 days, so I will try to keep this brief. I just want to touch on a couple of points, primarily about the record. I just want to point out that your honors have an order from the trial court judge stating that the record as submitted and supplemented by the trial court is accurate. According to Rule 24E of the Rules of Appellate Procedure, that finding is conclusive. There is not a significant discrepancy between the oral instructions and the written instructions, and this court will see that when it reviews the record. To touch briefly on the original supplementation of the record, because it was suggested by the defendant that may be some form of notice, some form of way of allowing the parties to be heard. When the Court of Criminal Appeals ordered supplementation of the record, it said that it was in the order that it was doing so for purposes of considering the issues raised in the brief, not new issues. And just finally, Justice Kirby, Justice Lee, I think you kind of hit on an issue with this, that when the intermediate appellate courts hear these issues without giving us a opportunity to be heard, it's an equal problem for both sides. It's not just a problem for the state. It's a problem for the defendant, and it's really not fair for him to be here trying to defend that as a result of the Court of Criminal Appeals not giving us an opportunity to be heard. So if there's no further questions, I ask this court to reverse. Thank you, Your Honors.
Thank you.
All right, we'll be adjourned until May 3rd in Knoxville.
All rise.